This lecture introduces the topic of contracts by defining a number of terms, giving an overview of the topic, and looking at the judicial interpretations of contracts. Contract law shows what promises or commitments our society believes should be legally binding. It shows what excuses our society will accept for breaking promises. And it shows what kind of promises will be considered to be against public policy and therefore legally void. The use of contract principles to govern the relationships of those who make promises to one another dates back thousands of years. Early in history, the importance of contracts was recognized and given legal effect. Modern capitalist society could not exist without the law of contracts. The foundation for most commercial activity is the contract. We could not order our daily activities without contracts. We're going to explain how contracts are formed and how they're discharged, and what happens when they are not performed. We will cover the objective theory of contracts. We'll list the basic requirement of contracts. We'll contrast the express versus the implied contracts. We'll summarize the difference between executed and executory contracts. And then we'll state the differences among valid, voidable, enforceable, unenforceable, and void contracts. All contractual relationships involve promises, but all promises do not necessarily establish contractual relationships. A contract is a promise for the breach of which the law gives a remedy, or the performance of which the law recognizes as a duty. In other words, an agreement that can be enforced in court. A contract may be formed when two or more parties promise to perform or to refrain from performing some act now or in the future. A party who does not fulfill his or her promise may be subject to sanctions, including damages or, under some circumstances, being required to perform the promise. Here is the definition that we are going to focus on. A contract is a legally enforceable agreement that meets certain specified legal requirements between two or more parties, in which each party agrees to give and receive something of legal value. The intent to enter a contract is important in the formation of a contract. The objective theory of contracts determines intent. Under this theory, a party's intention to enter into a contract is judged by outward objective facts as a reasonable person would interpret them, rather than by a party's own secret, subjective intentions. Objective facts include what the party said, how the party acted or appeared, and the circumstances surrounding the action. We're going to take a look at an example of a contract and the objective theory of contracts. Panhandle Realty, LLC, and Robert OLINS signed a lease for a new home in Westport, Connecticut. OLINS gave Panhandle a check for the first year's rent. A few days later, OLINS stopped payment on the check and told Panhandle he no longer had an interest in the property. Panhandle was unable to secure a new tenant and filed a suit in the Connecticut State Court against OLINS. The defendant argued that when he signed the lease, he did not intend to be bound by it. The court ruled in Panhandle's favor and OLINS appealed. When Panhandle and OLINS signed the lease, did each party intend to be bound to it? Yes. In a 2013 case, Panhandle v. OLINS, a state intermediate appellate court affirmed the lower court's ruling. There was nothing to support OLINS' contention that he did not intend to be bound by the lease when he signed it. His apparent change of heart did not negate the parties' meeting of the minds that occurred when the lease was signed. This mutual assent was indicated by their signatures on the lease and OLINS' first payment of the first year's rent. So let's look at what the court decided. The court found that the plaintiff proved the parties had entered into an enforceable lease agreement, that the defendant had breached that agreement, and the breach had caused the plaintiff damage in lost rent and utility bills. So how did the objective theory of contracts affect the result in this case? In this case, OLINS, the defendant, claimed on appeal that the lower court improperly determined he and Pan entered into a valid lease. OLINS contended that material terms were still being negotiated and various issues were unresolved, and thus there was no meeting of the minds to form a contract. The appellate court applied the objective theory of contracts. The court found no evidence in the record to support OLINS' contention that he did not intend to be bound by the lease when he signed it, or that the terms of the lease were still being negotiated at that time. The defendant's apparent unilateral change of heart regarding the lease agreement does not negate the parties' prior meeting of the minds that occurred at the time the lease was executed. There is ample evidence in the record evincing the intent of the parties to be bound by the lease when they signed it, and thus to support the lower court's finding that the lease agreement was a valid and binding contract, which the defendant breached. So let's go into some more specifics. Well, the defendant never moved into the house. Why then did the court find that he breached the lease? Well, under the lease, Pan, the plaintiff, was obligated to make modifications to the premises, specifically, for example, by removing furnishings, and OLINS, the defendant, had other obligations, such as paying a certain amount of rent. Pan met its obligations, but OLINS did not. The defendant issued a stop payment order on his rental check and told Pan simply that he is unable to pursue any further interest in the property. Pan made substantial efforts, including spending $80,000 to restage the property, but was not able to find a new tenant. In Pan's suit against OLINS, the court found that the plaintiff proved the parties had entered into an enforceable lease agreement, that the defendant had breached that agreement, and the breach had caused the plaintiff damages in lost rent and utility bills for the period of the lease. On finding that the defendant breached the lease, what did the court impose as a sanction? How was this determined? On finding that the defendant, OLINS, breached the lease, the court awarded the plaintiff, who's Pan, compensatory damages in the amount of $146,000, $138,000 in unpaid rent for the term of the lease, and $8,000 in utility fees incurred by the plaintiff during the lease period, plus interest and attorney fees. Well, OLINS, the defendant's appeal. On this, a state intermediate appellate court affirmed the lower court's judgment and award. The appellate court set out the standard for this award, stating, as in any other contract action, the measure of damages is that the award should place the injured party in the same position as he would have been in had the contract been fully performed. Thus, the unpaid rent may be used by the court in computing the losses suffered by the plaintiff by reason of the defendant's breach. Did the measure of damages assessed in this case place Pan in the same position that it would have been if the lease had been fully performed? Yes, it would. The measure of damages imposed on OLINS, the defendant, in this case placed the plaintiff in the same position that it would have been if the lease had been fully performed. And that is the standard measure of compensatory damages. On finding that the defendant breached the lease, the court awarded the plaintiff compensatory damages in the amount of $138,000 in unpaid rent and $8,000 in utility fees, plus interest and attorney fees. On the defendant's appeal, a state intermediate appellate court affirmed the lower court's judgment and award. Before the lease began, Pan spent funds to meet its obligations under the parties' contract, but this was not compensable as damages because the lease required Pan to undertake these duties, and they were accomplished before the defendant's breach. Later, in an attempt to reduce the amount of damages, Pan spent additional funds in an unsuccessful effort to find a new tenant. Neither court included these funds in the measure of damages. A contract is more than an agreement between two people. There must be an offer, an acceptance, intention to create a legally binding agreement, a price paid, which isn't necessarily money, a legal capacity to enter a contract on one's own free will, and proper understanding and consent of what is involved. In addition, the purpose of the contract must not violate any laws. Any duress, false statements, undue influence, or unconscionable dealings could make a contract illegal and void. There are defenses to the formation or enforcement of a contract. In other words, the defense would be what the defendant can use to be able to legally exempt him from a contract. One is voluntary consent. The consent of both parties must be voluntary. If a contract is formed as a result of fraud, undue influence, mistake, or duress, the contract may not be enforceable. And then there's another defense for form. The contract must be in whatever form the law requires. Some contracts must be in writing to be enforceable. There are types of contracts. Each of these categories signifies a legal distinction regarding a contract's performance, formation, or enforceability. We'll take a look at the valid, void, voidable, unenforceable contracts, the executed and the executory contracts, the bilateral and unilateral, the express, the implied, and quasi contracts, along with formal and informal contracts. Bilateral versus unilateral contracts. Every contract involves at least two parties, an offeror and an offeree. The offeror promises to do or not to do something that he has a right to do. Whether a contract is unilateral or bilateral depends on what the offeree must do to accept. A bilateral contract is a promise for a promise. If the offeree need only promise to perform, the contract is bilateral. For example, in a contract for the sale of a home, the buyer promises to pay the seller $200,000 in exchange for the seller's promise to deliver title to the property. A unilateral contract is a promise for an act. If an offeree can accept only by complete performance, a contract is unilateral. A unilateral contract's offer becomes irrevocable once substantial performance is completed. In a unilateral contract, only one party to the contract makes a promise. A typical example is the reward contract. A promises to pay a reward to B if B finds A's dog. B is not obliged to find A's dog, but A is obliged to pay the reward to B if B finds the dog. In this example, the finding of the dog is a condition precedent to A's obligation to pay. An offer of a unilateral contract may often be made to many people or to the world by means of an advertisement. In that situation, acceptance will only occur on satisfaction of the condition, such as finding the offerer's dog. The most common type of unilateral contract is the insurance contract. The insurance company promises to pay the insured a stated amount of money on the happening of an event if the insured pays premiums. Note that the insured does not make any promise to pay the premiums. Here's an example. The Golden Gate Bridge is an example where two individuals, Simone and Jack, enter into a contract where Simone says, or Jack says to Simone, if you walk across this bridge, then I will do this for you. So, if without saying a word, Simone walks across the bridge, do she and Jack have a contract? Well, yes, they do. They have a unilateral contract, which can be accepted only by performance. The performance in this case was Simone walking across the bridge. If Simone tells Jack no and turns and walks away, are there any legal consequences? Nope. Unilateral contracts are only a promise for an act. Without the act, there's no contract and there are no consequences for not acting. If no one says anything more, but Barry, rather than Simone, starts to walk across, do Jack and Barry have a contract? Nope. Only the person to whom the offer is made can accept the contract. An express contract is one in which the terms are expressed in words, oral, or written. A contract that is implied from the conduct of the parties is an implied contract. The parties' conduct reveals that they intended to form a contract and creates and defines its terms. To establish an implied contract, the plaintiff must have furnished some service or property. The plaintiff must have expected to be paid, and the defendant knew or should have known that payment was expected. And the defendant had a chance to reject the service or property and did not do so. A quasi-contract is not based on an express promise to pay for a benefit received or on conduct implying such a promise. Quasi-contracts, or contracts implied in law, are imposed by courts to avoid unjust enrichment. The theory that individuals should not be allowed to profit or enrich themselves inequitably at the expense of others. There are situations in which the recipient of a benefit is not liable. People cannot normally be forced to pay for benefits thrust on them, for example. A simple statement of what the doctrine of quasi-contracts is all about is this question: of all the benefits that people confer, which ones should the law extend recovery for and why? Is the mere fact that a person benefits another enough to require the other to pay? For example, a property owner who improves her property benefits her neighbors to some extent, but should she be entitled to payment from them? Ordinarily, to obtain relief under the quasi-contract doctrine, there must be a sort of trade-off, a benefit to one party and a loss to another party. Here's an example of a quasi-contract. Zablocki offers to pay Len to paint a house located at 123 Laurel Avenue. Len accepts, but writes down the wrong address and consequently paints the wrong house. Well, Olivia, the owner of the house that Len paints, sees Len painting her house but says nothing. When the job is finished, Len tries to collect first from Zablocki and then from Olivia. Both of them refuse to pay. Who can Len recover from? Well, Len can recover from Olivia under the theory of quasi-contract. Olivia knew of the benefit conferred on her and accepted it, even though no contract was formed between Len and Olivia. Formal contracts require a special form or method of formation to be enforceable. Formal contracts include negotiable instruments, which include checks, drafts, promissory notes, and certificates of deposit. All other contracts are informal contracts or simple contracts. For these, no special form is required, except for certain types of contracts that must be in writing. Executed contracts versus executory contracts. A contract that has been performed is an executed contract. A contract that has not been performed is an executory contract. If one party is fully performed but the other has not, the contract is said to be executed on one side and executory on the other, and it is classified as executory. One example of this type of executed contract would be a contract for purchase of a major appliance. This contract is entered into and the appliance is immediately delivered. An example of an executory contract may be a contract with a general contractor for the construction of a house. for which the work is to begin in 4 months' time. The important thing to understand is that in either case, once a contract has been signed by all parties, it becomes legal and binding. John's been looking at a car he wants at a car lot, debating whether to buy it. Finally deciding to make the purchase, John walks into the dealership, signs a purchase agreement, and pays for the car in cash, and walks out with the keys to the car. That's an example of an executed contract. John has been looking at a car he wants at the car lot, debating whether to buy it. Finally deciding to make the purchase, John walks into the dealership, signs a lease contract agreeing to pay a specific amount of money each month until the car is paid off. Or he returns the car at the end of the lease. Until the car is either paid off or returned, the terms of the contract have not been fulfilled. This example is an executory contract. A valid contract results when all of the elements necessary to contract formation exist. When the parties agree through an offer and an acceptance to form a contract, the contract is supported by consideration. The contract is for a legal purpose and the parties had legal capacity to contract. A voidable contract is a valid contract in which one or both of the parties have the option of avoiding his or her legal obligations. If the contract is avoided, both parties are released. If it is ratified, both parties must perform. An unenforceable contract is a valid contract that cannot be enforced due to certain defenses. For example, a valid contract barred by a statute of limitations is an unenforceable contract. A contract that is void is no contract. A void contract gives rise to no legal obligation on the part of any party. An illegal contract is, for example, a void contract. Valid contracts are if the contract has all the required elements. It's valid and it's enforceable in a court of law. A homeowner who's over the age of 18 and of sound mind signed a contract with the appliance store to buy a refrigerator. The homeowner pays for the refrigerator and the appliance store presents the refrigerator for the homeowner to take home. That's a valid contract. A voidable contract is a contract which may appear to be valid and has all the necessary elements to be enforceable, but has some type of flaw which could cause one or both of the parties to void the contract. The contract is legally binding, but could become void. If there is an injured party involved, the injured party or the defrauded must take action. Otherwise, the contract is considered valid. An example of this type of contract is one entered into with a minor. This could be voidable. An unenforceable contract is a contract which cannot be enforced in the court of law. This could happen because the terms of the contract are ambiguous, if one party has a voidable contract, or if the statute of limitations has expired. The statute of limitations requires that lawsuits be filed within a certain period of time following a breach. The unenforceable contract is valid on its face, but may not be enforced by the courts should one of the parties refuse to carry out the terms of the contract. For example, if a contractor paints the homeowner's interior walls as agreed by the homeowner, but the homeowner doesn't pay, the homeowner is in breach of contract. If the contractor fails to seek court action within the statute of limitations, the court will not help either party receive compensation or damages for breach of contract. Even though the contract was valid and enforceable, the expiration of the statute of limitations voids the contract between the parties and no damages can be awarded. A void contract is not a contract and has no effect in the court of law. It cannot be enforced in a court of law. Most commonly, a void contract will be missing one or all of the essential elements needed for a valid contract. Neither party needs to take action to terminate it. since it was never a contract to begin with. A contract that was between an illegal drug dealer and an illegal drug supplier to purchase a specific amount of drugs for a specified amount. Either one of the parties could void the contract since there is no lawful objective and hence missing one huge element of a valid contract. E-contracts are contracts entered into online. Generally, e-contracts are governed by common law principles and new laws such as the Uniform Electronics Transactions Act. The most important principle to keep in mind in considering these rules is that the law attempts not just to enforce a contract, but to enforce the contract the parties made. When a contract is in writing, that is not subject to conflicting meanings. A court will enforce the writing according to its plain meaning. The meaning of the words must be determined from the face of the instrument. A court cannot consider evidence extrinsic evidence. If a contract is ambiguous, a court may consider outside evidence, such as the testimony of the parties, additional agreements or communications, and other information relevant to determining the parties' intent. A contract is ambiguous when the intent of the parties cannot be determined from the language, the contract lacks a provision on a disputed issue, a term is susceptible to more than one interpretation, there is uncertainty about a provision. The terms of an agreement or promise generally define the obligation. When the parties to a contract have adopted a writing as the final expression of all or part of their agreement, interpretation focuses on the writing. Here's a good example. A agrees to sell and B agrees to buy a quantity of eviscerated chickens. A tenders stewing chicken or fowl. A tenders stewing chickens or fowl, while B rejects on the ground that the contract calls for broilers or fryers. Each party makes a claim for damages against the other. It's found that each acted in good faith and that neither had reason to know of the difference in meaning. The plaintiff foreign corporation's complaint was dismissed where the plaintiff did not sustain its burden of persuasion that the contract with the defendant, state sales corporation, used the word chicken in a narrower sense, and the defendant's subjective intent coincided with an objective meaning of chicken. There you have it for contracts. As we end this, a little humor is always great. As this says, we have a 30-year mortgage, a 5-year car lease, and a lifetime gym membership. But you're afraid of commitment?